Good evening. Happy Thursday. I want to say, first of all, that yes, I did watch the first Chillie live stream where he went over his motion for sanctions from spoliation. It's not worth my time to go over it. It would take hours for me to go over everything he got wrong. So I'm just not going to. I will maybe get to his motion for sanctions for spoliation of evidence today in this. Actually, I'll probably go over the memorandum and declaration in support because I believe I have already gone over the motion itself. And it's still wrong for all the reasons I said earlier. But anyway, some things happened today that are worth talking about, or at least noticing. Josh Abrams has a new attorney. Joshua N. Garrick has filed a notice of appearance and immediately basically Me Too'd onto Kate Peters' motion to dismiss or for equitable relief. And then he filed an affidavit of Josh Abrams basically alleging all the terrible things that Chillie's done as a reason why the court should grant the motion to dismiss or in the alternative for equitable relief as it relates to Josh Abrams. This is basically just Josh's attorney saying, yeah, we want in on that motion too. We're gonna let Kate's attorney lay out the groundwork. We join in on it, and we make the same arguments too. Then, a little after that, Kate's attorney filed his essentially expanded motion to dismiss or in the alternative for equitable relief. He had filed a motion for emergency status conference seeking the dismissal or equitable relief, and the court said, okay, we didn't get Chillie here, so you've got until Thursday at, I forget what time the court gave him till. Basically, it was a very short window of time to prepare this motion and file it, and then Chillie has until I think 9 a.m. on Monday to respond, and I believe the hearing, if I remember correctly, was sometime around, what was it, 10 o'clock? Anyway, it was a very short window. This is an emergency kind of relief docket. So things got going. And then Kate and her attorney both filed affidavits in support of the motion. So the motion is pretty good. We'll go through it. Defendant Ms. Peter, hereby requests on an emergency basis that the court dismiss with prejudice the complaint of plaintiff Jose Maria de Castro. So dismiss with prejudice means that he can never bring this cause of action again. Now, one thing that Chillie doesn't understand is, could he sue again, alleging these? Yes, he could. But what would happen is a motion to dismiss would be filed, probably seeking sanctions for a frivolous filing, and the court would dismiss it because it was dismissed with prejudice. So one thing that Chillie understands is, like, can you sue over emails? Yes, you could sue over anything. I could sue anybody out there who's listening to this video. I could sue anybody out there who's never even heard of me. I could sue anybody, anywhere, anytime for anything. The question is, can I recover? Will the court grant me the relief I'm asking? That's the difference. So, but if it's dismissed with prejudice, that means that it's basically barred. He's barred forever for recovering for the causes of action that he is alleged in this. So they're asking for a dismissal with prejudice and further to enter a permanent injunction that Chillie shall not threaten and harass Kate, all counsel of record, and witnesses in this action. So that's a pretty big ask. They're going for a permanent injunction. As far as there is a very low probability of the permanent injunction. Super low. It's possible, but it's super low. Like it's possible for Chillie to pass the bar, right? It's possible, but the odds are super low. That's what this is. I'm not saying that the judge can't grant it. I'm just saying that in my first year family law attorney experience, the odds of it are super low. The dismissal with prejudice, I would say you have reasonable odds, but it's more likely that the court is not going to grant the dismissal with prejudice than that it would grant the dismissal with prejudice, if that makes sense. Most likely the court will not grant the dismissal with prejudice. There's a possibility it will. There's even a probability that it will, but it's not more probable than not. In the alternative, Ms. Peter requests this court order that Mr. DeCastro shall not threaten and harass Ms. Peter, all counsel of record, and witnesses in this action, and that any violation of that order shall result in a dismissal of his claims. Mr. DeCastro is using this. This is I think much more probable. I think this is more probable than not. I think this is in the range of very, very likely that the court is going to grant some version of this. Like, okay, Mr. DeCastro, you can only speak to counsel. You can't speak to Miss Peter. You can't speak to Mr. Abrams. You can only speak to counsel. And you need to stay focused and don't threaten anybody and don't, get all hostile or anything like that. You got to follow the rules, buddy. Mr. DeCastro is using this litigation as a tool to harass and threaten Ms. Peter, undersigned counsel, witnesses, and others, and is intentionally defying court orders to facilitate his efforts to do so. Courts usually don't like it when you defy their orders, and Chillie is, in fact, defying the court's orders. Particularly where Mr. DeCastro has repeatedly conceded the purpose of this litigation is simply to drain Miss Peter of her resources and not to win, and has already been executing on that plan. Miss Peter respectfully submits that dismissal is appropriate and necessary, including to maintain the integrity of this court. Denying the motion would send a clear message to Mr. DeCastro and to the world. Litigation may be used as a weapon to deplete a party's resources. Ms. Peter submits that the court should send the opposite message by dismissing the lawsuit. Litigation is for determining the rights of the parties, not for harassment. Now, I strongly agree that the court should dismiss this with prejudice. Chillie's actions are pretty egregious. I mean, he's making videos today instead of actually writing a response to this motion. So, I mean, he's flaunting the rules. He's basically saying that no matter what happens, he's just going to grind everybody down and sue and sue and sue, and everybody gets sued. You get a lawsuit, and you get a lawsuit. It's the Oprah Winfrey, everybody gets a car routine. Except with Chillie DeCastro, it's a lawsuit. And I don't think that the court should entertain that kind of behavior. But that's just me, I'm dumb. Mr. DeCastro is a YouTube personality and content creator on the YouTube channel called Delete Laws. He explained to Ms. Peter that he planned to initiate this litigation even though, in quotes, I don't care if I win, end quote, because, quote, I care that you have to hire a lawyer, ellipses. I care that I extend the process for as long as I can to drain you, end quote. Affidavit of Kate Peter, Peter Affidavit, Exhibit A. Indeed, on September 7th, 2022, Mr. DeCastro stated on his YouTube channel, eventually I'm going to get them because the thing is that I will break them financially. They will have to hire a lawyer. I will file motion after motion after, and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them. He has written to defendant Joshua Abrams, Mr. Abrams, quote, this is just the beginning. You made a grave error in choosing to tangle with me. Heed my warning. I will not stop until I break you down to zero. We don't stop, end quote. That's from the affidavit of Joshua Abrams, Abrams affidavit. Mr. DeCastro has decided to do anything he believes will further his goals regardless of this court's orders. Already, he has refused to appear for a court-ordered hearing based on his claim that the court didn't properly serve him, despite the court service via the email address on file with the court and which Mr. DeCastro has included in his signature block on multiple pleadings. Yeah, I mean, that's really dumb of Chillie to do that. It was really dumb. I mean, the proper response, if there is some sort of emergency thing, you appear. Even if you think service is improper, you appear. And then you say to the court, your court, I think I was not properly served. And then the court will do whatever it needs to do, right? The court might say, okay, well then I'm going to continue this hearing for another X number of days to allow the moving party to properly serve the non-moving party. That's what happens. I mean, I know that Chillie thinks that the courts are all about just cutting things off. And, oh, you didn't follow the rules, so things end. And the court's not like that, which is why I am specifically saying that I don't think the court's going to dismiss Chillie's case with prejudice. I don't think they'll do it. They could, but I don't think they'll do it because that's not what the court wants to do. The court wants this to be heard on its merits so that everybody has their day in court and gets to feel like they at least got to make their argument to the jury, or if there is no jury, to the judge. That's what the court wants. Consonant with Mr. DeCastro's plan to use this litigation as a means to, quote, drain, end quote, Ms. Peter, and as the affidavits filed in support of this motion detail, Mr. DeCastro makes it his practice to harass, threaten, and taunt parties in counsel to seek to get what he wants. He has repeatedly threatened Ms. Peter, see generally the Peter affidavit. He has sought to intimidate undersigned counsel as well. He has asked his approximately 48,000 subscribers. Bullshit. I mean, he does not have 48,000 subscribers. I mean, he might have paid for that many, but he doesn't even have close to that many. He has asked his approximately 48,000 subscribers on YouTube to, in quote, fill out or find out everything they can, end quote, about undersigned counsel in a transparent attempt to find some information to use as leverage against counsel in this litigation. Yeah. And how'd that work out for you, Chillie? Apparently, he has even sought to blackmail a third-party witness in order to extract an affidavit. As an email from a third party to this court reflects, Mr. DeCastro threatened to expose that third party on his YouTube channel in order that his supporters could take whatever action they wished against him unless that third party provided an affidavit for him to use in this litigation. And then, in order not to publicize the identity of this third party, Ms. Peter respectfully refers the court to the emails which this individual has sent to the court. Now, I thought someone... Did they redact? They did not redact. Huh. Well, well, good job on keeping his identity a secret. Where were we at? Mr. DeCastro is not just an online harasser, but poses a real physical threat. He once showed up at Mr. Abrams's home with 2 unlicensed firearms, a shotgun, and a handgun revolver. Abrams affidavit, paragraph 14. Litigation is a vehicle for determining the rights of the parties and ordering appropriate relief. It is not a vehicle for abuse, threats, and harassment. Allowing Mr. DeCastro to continue to seek to use this court to drain and destroy Ms. Peter, as he has declared he intends to do, would allow Mr. DeCastro to undermine the integrity of this court and pervert the legal process to enable him to use this process as a tool for harassment and abuse. Ms. Peter respectfully submits that this court should not allow Mr. DeCastro to do so. Relevant factual and procedural background. Ms. Peter is a full-time residential property manager, mom of 2 children, aged 16 and 13, and in her spare time runs a YouTube channel called Masshole Troll Mafia. In or around April 2022, Ms. Peter, that's an unfortunate name, by the way. In or around April 2022, Ms. Peter began to post videos on her YouTube channel regarding Mr. DeCastro, also a content creator, who runs a YouTube channel called Delete Laws. Disagreeing with the content of that channel, which is vehemently anti-government and anti-police, Ms. Peter began to research Mr. DeCastro's background and post videos about him. Almost immediately, Mr. DeCastro sent Ms. Peter what he purported to be a cease and desist letter via a third party, Mr. Abrams, but in reality, the first of many threatening and harassing messages that Mr. DeCastro would send to Ms. Peter. In the message, Mr. DeCastro wrote, quote, "You're damn lucky we have a legal system, and I'm a man of law and order, or I would let you know when I was coming, so I could see the look of tear on your face as closed it." He went on to write, quote, "I will check your social media channels for the retraction. If it is not complete and full, you will be served with a lawsuit next week. I don't care if I win. I care that you have to hire a lawyer. I care that I extend the process for as long as I can to drain you." As set forth in Ms. Peters' affidavit, Mr. DeCastro's threats to harm Ms. Peter continued from there, and his threats were not idle. Mr. DeCastro attempted to take out 2 baseless harassment and protection orders against Ms. Peter, once in Woburn District Court and once in Attleboro District Court, both of which were denied, and called the Attleboro Police Department to report Ms. Peter. When the officer was not receptive to Mr. DeCastro requested permission from the officer to, quote, "handle," end quote, the situation, Ms. Peter, on his own. Mr. DeCastro's pre-litigation antics culminated on September 3rd, 2022, when he traveled from California to Boston to, quote, "serve," end quote, Ms. Peter personally while she attended an unrelated court hearing in Roxbury District Court. While court was in session, Mr. DeCastro approached Ms. Peter as she sat in the gallery, leaned down and stated, "This is just the beginning. You have no idea what's coming for you. You have no idea. I am going to destroy you." An associate with Mr. DeCastro then threw a manila folder at Ms. Peter and yelled, "In the middle of open court, you've been served." Court officers escorted Mr. DeCastro and his associate out of the courtroom. Mr. DeCastro's harassment and intimidation tactics only worsened after he filed this lawsuit, with repeated messages of how he planned to, quote, "take these people down," end quote, and, quote, "attack," end quote, the defendants in this litigation, telling his followers, quote, "Eventually I'm going to get them, because the thing is that I will break them financially. They will have to hire a lawyer. I will file motion after motion, and I'll keep going after them legally, or I'll keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them." The next day, with regard to the legal process, Mr. DeCastro stated, and this is a long quote, "It just takes a long time. The wheels of justice spin slowly, but they are crushing as they come around." And so, I mean, anybody who's ever dealt with the legal system knows that when all of a sudden you have to do these horrific hoops you have to jump through, well, these folks are about to meet some horrific hoops. It's because it'll never stop either. I'll just keep on hammering them. The third prong hasn't even dropped yet. Mr. DeCastro has continued to threaten Ms. Peter through email and through his YouTube broadcasts. Mr. DeCastro's attacks did not end with Ms. Peter. After learning that Ms. Peter had retained counsel, Mr. DeCastro began a course of emailing Ms. Peter's counsel and leaving him threatening and harassing voicemail messages as well. As set forth in the affidavit of Benjamin Wish, the very day undersigned counsel reached out to Mr. DeCastro. Mr. DeCastro left him a voicemail, which Mr. DeCastro then posted to YouTube, which concluded with the statement, "You're not my daddy. I have no obligation to you. None. I don't know you a goddamn thing. You're a blood-sucking law lawyer who doesn't give a shit about justice. You're doing court law cases. You don't give a shit about justice or the rule of law or the Constitution or America." Worse, Mr. DeCastro has directed his online supporters to go after the undersigned counsel. He has asked his 48,000 subscribers to, quote, "find out everything about this guy," end quote, in a transparent effort to seek to gain some leverage over counsel. Now, all things being equal, the exchanges between Kate and Chillie make them both look like bad people. Okay? I just want that to be clear. She said some shit to him. He said some shit to her. There's a difference between them, though. The difference between them, though, is that, number one, Chillie threatened to use and abuse the legal system against Kate. That's the defining difference. Now, in Kate's affidavit, which I'm probably not going to get into, she does throw in some things that are just Chillie's a bad guy. And you do that as an attorney, as a pro se litigant. You throw in everything, hoping to prejudice the judge against the other party. Great. I understand it. But the important thing is, and the thing that the judge is going to key in on, is Chillie threatening to abuse the process, not use the process, but to abuse the process to punish Kate. It's that whole thing, with cops. You could beat the rap, but you can't beat the ride. And cops can abuse their ability to detain you, to arrest you without ever charging you for anything, right? They can make life hell for you without you ever actually going to court. That's what Chillie's trying to do. And the court doesn't like that. The court's not going to be happy with that. So the difference between the tit for tat emails that Chillie and Kate sent to each other is that Chillie threatened to abuse the legal system, to abuse the process, to punish Kate. That's the big difference. Now, the other big difference, there's one other mitigating factor for Kate that's really going to come in handy for her, is that Benjamin Wish, her attorney, didn't do anything wrong. Did nothing wrong. Every single email that he sent was professional. Every contact he had with Chillie was professional. He didn't rise to any of Chillie's bait. He didn't do anything wrong. And Chillie was a dick and threatened him. So the court is going to see, look, this attorney didn't do shit to Chillie. And Chillie was still aggressive and threatening and all this other stuff to the attorney. And so because of that will have a stronger prejudicial impact on the judge than just if it had been Chillie attacking Kate and Kate attacking Chillie verbally, not physically, obviously. Although Chillie did physically attack Kate in a video, which is probably also going to prejudice the judge. So that's, but the big difference if it was just Kate's emails and videos versus Chillie's emails and videos, the big difference, the overwhelming difference, the important difference is the threats by Chillie to abuse the legal process. Okay. Mr. Castro now, apparently, Mr. Castro, all right. Mr. DeCastro is what it should be, obviously, has already acted to, and I might point these out when I stumble on them, and I there's a lot that I'm just gonna gloss over. This is not anything like this attorney had a day or something to come up with this and to go through all the relevant videos and all the emails and to put this together. If he does some misspellings, like it doesn't matter. Like, this guy did a ton of work. This is an excellent motion. I'm not giving him any crap over it. Mr. DeCastro has already acted to seek to manipulate and impede the judicial process. That is a tortured sentence. Mr. DeCastro has already acted to seek. Mr. DeCastro has already attempted to manipulate and impede the judicial process. That's what I would say, but that's a tortured sentence. Specifically, on October 18, 2022, counsel learned that Mr. DeCastro appeared to have engaged in witness intimidation in an attempt to gather false evidence to use in this litigation. Specifically, Mr. DeCastro has threatened others, including by saying he will dox, in quotes, identify the identity, address, and other personal information of a person on the internet, potential witnesses in this litigation, and send his supporters after him unless those third parties provide affidavits in support of Mr. DeCastro's claims in this litigation. Mr. DeCastro appears to have so intimidated one witness that the witness directly contacted the court and advised that he was fearful that he was in danger. Specifically, that witness wrote to the court, over the course of the last 2 weeks, this is a quote, over the course of the last 2 weeks, I've been blackmailed and extorted by the plaintiff, Jose Maria de Castro, to produce documentation and evidence to support his case over fear that he will put my entire life and identity online. I know that I am not the only person he is currently doing this to, but right now I have a credible threat that tonight, in all caps, he will be posting a video where he has taken my full details and created multiple videos about me. I'm going I'm trying to find a lawyer as well as contact both law enforcement and Google/YouTube. I'm hoping that the judge could possibly intercede with some type of cease and desist action. Please help me. This man is very, very dangerous. He has proven over and over and over again with others that he does not make idle threats. The people who follow him are of a similar mindset, and I have a credible fear for my life. End quote. Further, Mr. DeCastro has demonstrated his willingness to violate the court orders if he believes doing so will benefit him. He took the position that he had not received notice of an order to appear for a status conference in order to avoid appearing for the October 18, 2022 status conference, which this court ordered. The court ordered an emergency status conference on October 18, 2022 at 4 p.m. and ordered all parties to appear. There is no question that Mr. DeCastro received notice of the status conference. The court sent him notice to the email address on the court's public docket, IamAlaskan@gmail.com. Undersigned counsel sent it to him at the address at which counsel had been corresponding with Mr. DeCastro, and counsel and Mr. DeCastro spoke about the impending status conference just before it was to begin. That's Wish Affidavit, paragraphs 8 to 12. Nonetheless, Mr. DeCastro has sworn under oath that, among other excuses, he did not appear for the status conference because, in quotes, I obviously had not received proper service, end quote. See Exhibit C at 4. Now, the funny thing is, Exhibit C is... This is Exhibit C. Exhibit C is plaintiff's memorandum. He actually used Chillie's memorandum. Chillie is so stupid. Chillie's so stupid that under penalty of perjury, this stupid idiot said, I ignored the court's order. I didn't get proper service. Yeah, the court didn't give you proper service, dude. What a dunce cap. You're a dunce cap. Jesus criminy. One thing you should never, ever, ever do, among the many things that you should never, ever, ever do, is never sign under penalty of perjury in a document you are going to submit to the court that you ignored the court's order willingly. Ugh. In other words, Mr. Castro refused to appear for a court-ordered hearing because it was his position that the service of the order the court provided was not proper. Mr. DeCastro did not appear at the status conference, and the court put on the record the means by which it had provided notice to Mr. DeCastro. Now we're in the argument. This is the legal argument. Courts do not tolerate litigants using the legal system to engage in abusive behavior. Upon recognizing that a party is using the litigation as a tool for harassment, courts routinely dismiss the litigation. Here, the court does not need to engage in intensive fact-finding to reach the conclusion that Mr. DeCastro has weaponized this litigation. He has announced it to the world on his YouTube channel and has cataloged the many respects in which he has already harassed and threatened Ms. Peter, witnesses, and undersigned counsel. A district court has the inherent power to fashion remedies to address issues that arise during litigation on a case-by-case basis. Indeed, it has long been the rule that federal courts possess plenary authority to manage their own affairs so as to achieve the orderly and expeditious disposition of cases. Among other things, where a party's behavior is egregious and willful or conducted in bad faith, it is well within the court's discretion to dismiss a case outright. Such a sanction is permissible where a party is engaged in conduct utterly inconsistent with the orderly administration of justice, and totally at odds with the federal rules of civil procedure and the notions of fairness central to our system of litigation. Indeed, the ability to issue the sanction of dismissal, in quotes, must be available to the district court in appropriate cases, not merely to penalize those whose conduct may be deemed to warrant such a sanction, but to deter those who might be tempted to such conduct in the absence of such a deterrent. Moreover, a sanction of dismissal need not be preceded by other, less drastic sanctions. On the contrary, a court may apply this strong medicine for instances where the defaulting party's misconduct is correspondingly egregious. See also this First Circuit case dismissing a complaint for failure to respond to discovery, holding that a court is not necessarily required to attempt less severe sanctions before turning to the sanction of dismissal, nor is a court required to provide an adversary hearing before imposing the sanction. And see also Brockton Savings Bank versus Pete Marwick Mitchell and Company, which is also a First Circuit Court of Appeals case. Great deterrent value is to be derived from the imposition of sanctions for such abusive litigation practices, and there is no requirement that other sanctions must be first considered or tried. In deciding whether to dismiss a claim as a sanction, the judge should carefully balance the policy favoring adjudication on the merits with competing policies such as the need to maintain institutional integrity and the desirability of deterring future misconduct. Applying this principle, courts have dismissed cases outright for, among other things, obtaining a written statement from a witness through deceit, fabricating evidence, abusing litigation tactics, including through spoliation of evidence, and disregarding court orders. So we've got 1, 2, 3, 4 out of 5. Well, maybe he's done some spoliation, I don't know. Application of the First Circuit's balancing test is straightforward here. Mr. DeCastro's claim should be dismissed because his actions have been utterly inconsistent with the orderly administration of justice. And, on the other side of the scale, he has conceded that he is not even trying to adjudicate the matter on the merits. As Mr. DeCastro admitted in his April 28, 2022 cease and desist letter to Ms. Peter, I don't care if I win, I care that you have to hire a lawyer. I care that I extend the process for as long as I can to drain you. After beginning litigation, Mr. DeCastro doubled down, emailing to Ms. Peter, Kate, I'm never going to stop until you're done. I will never, ever, ever, ever stop, and it's not just me. He announced the same intention to the world on his YouTube channel to use the litigation to break them financially. Mr. Castro has already demonstrated his willingness to disregard court orders to seek to accomplish these ends. He refused to appear for the October 18, 2022 Emergency Status Conference because he claims that the court did not provide proper service of its order, despite receiving notice via multiple email addresses and discussing the impending hearing with undersigned counsel. He is further seeking to undermine Ms. Peters' ability to have the assistance of counsel by requesting that his 48,000 followers dox undersigned counsel in order to try to gain some leverage over counsel. Mr. DeCastro's use of this litigation and this court to threaten and harass parties, witnesses, and counsel poses a real risk to the court's, in quotes, institutional integrity, end quote. If this court permits Mr. DeCastro to persist in litigating this case, given his repeated stated intention to use this litigation as a cudgel, it will send a clear message to Mr. DeCastro, his 48,000 subscribers, and the world. Parties may use litigation as a means to attack others financially and to harass them. Ms. Peters submits that the court should not send such a message. On the other hand, dismissing Mr. DeCastro's lawsuit will deter future misconduct by sending exactly the opposite message. Courts will not tolerate litigation targeted at harassing a party and draining their resources. Indeed, Mr. DeCastro's plan and tactics amount to a hornbook example of abusive process. Abusive process lies where a party uses the legal process to accomplish some ulterior purpose for which it was not designed or intended, or which was not the legitimate purpose of the particular process employed. The three elements of the cause of action are that process was used for an ulterior or illegitimate purpose, resulting in damage. Given the egregious nature of Mr. DeCastro's conduct, even at this early date, ranging from harassment of Ms. Peter and her counsel, refusing to follow court orders, and coercion and harassment of witnesses, one so badly that he was forced to seek protection from this court and law enforcement, as well as the bad faith nature of Mr. DeCastro's claims, it is well within the court's discretion to dismiss Mr. DeCastro's claims in their entirety. This will both prevent Mr. DeCastro from further using this litigation to harass the parties and third-party witnesses, and will deter others from similar conduct in the future. This court should further order a permanent injunction barring Mr. DeCastro from threatening and harassing Ms. Peter, all counsel of record, third-party witnesses to this matter and others. In the alternative, Ms. Peters submits that the court should enjoin Mr. DeCastro from engaging in such threatening or harassing behavior and further order that any further harassment or threats shall result in the immediate dismissal of this lawsuit. And respectfully submitted. There you go. So there was the affidavit of Kate Peter. I'm not going to go over it. There was the affidavit of Benjamin Wish. Not going to go over it. And now let's turn to Chillie's motion for sanctions for spoliation and abuse of process. Now that it's all filed and all that good stuff, I want to point out that discovery hasn't happened yet. So Chillie doesn't know whether or not any evidence was spoliated. Spoiled? Spoliated? I don't know. He doesn't know if the evidence has been destroyed. The way you find out that there's been spoliation of evidence is that you do discovery. The other party responds to your discovery and doesn't turn over the requested documents. And then you say, why? And they say, oh, well, we destroyed them in the normal course of business. And then you say, you were supposed to keep that. I need it. And then you get to prove that they did it and they shouldn't have done it, and they reasonably should have known that it was going to be used for litigation, and that you need it for the litigation, and etc. So his motion for spoliation, or his motion for sanctions for spoliation, is premature, to say the least. So there's that. But let's look at his memorandum and declaration in support of motion for sanctions for spoliation and abuse of process. Did he actually where's the abuse of process? Defendant Peter submitted this court documents. Hold on, I don't remember this. I am Alaskan at gmail.com. She submitted documents that were... I am Alaskan at gmail.com. It's been on all of his filings. This was from back in September on the Ironton case. That was his first amended complaint. I am Alaskan. This was from August. I don't know what the hell he's talking about. It wasn't the email address on the complaint? Do I have the original complaint? Documents. No. Downloads. Discord. And let's curated documents. Do. There we go. Is it this one? No. Is it this one? Yes. So he didn't use it on this one. Okay. Whoop-de-woo. By the way, if you only see landing pad, if you do join my Discord, I don't know why there are all these people in here who've joined my Discord but have never said anything. Because if you're in here, if you can see landing pad and you're not yellow, that means that you could only see a few things. You can't see main chat or any of the other fun stuff. You can only see landing pad, I think, open docs and curated docs and warning. Anyway, so okay, whatever. Anyway, all right. So this is the one that he just went over today, I think. So this is his memorandum and declaration in support of his motion for sanctions for spoliation. Again, he doesn't say that he doesn't say that anybody refused to turn over the documents to him. He just says that they destroyed them, which is funny to me. I have a confidential witness, John Doe, that is part of the inner circle of defendant Catherine Peter Zzz's organization of internet trolls named the Masshole Troll Mafia, Masshole, of which defendant Josh Abrams is a member. Okay. So just to start off with, confidential witnesses aren't really a thing in civil matters. There are like confidential informants in criminal matters who the government has a privilege. It's a literal privilege, i.e. It's kind of like a right. They could have confidential informants, and the purpose behind the privilege, it's kind of like the attorney-client privilege. It's a privilege. The purpose behind that privilege that they don't have to disclose who the informant is because they might want to use that informant again in the future. And they can use sealed affidavits from confidential informants to get warrants and things like that. And the defense counsel might be able to figure out or might be able to get the name of the confidential informant if there's some evidence that the confidential informant might have that is exonerating for the defendant. But generally speaking, the government can keep their confidential informants confidential because they have a privilege. It's a governmental privilege. Chillie does not have that privilege. And indeed, discovery is a thing, and if you're going to use something, you have to disclose that to the other side. Just like all the attachments that are attached to Kate's affidavit or her declaration and her attorney's declaration, all these things that are attached to the affidavits, they are served on Chillie. Chillie got copies of these. There should be down here somewhere a certificate of service. Or no, this is. I believe that this had to be served. I don't see a certificate of service on it, but I would assume it was served. These have to be served. You've got to give the other side your moving papers and the papers that you're filing in support of your moving papers, i.e. affidavits, which would contain exhibits. So you can't play hide the ball and have a confidential witness. You can't do it. So I know Chillie has experience with the criminal justice system, i.e. Where confidential informants might have given the police information about Chillie's GHB, what was it, manufacture and sale of a controlled substance. So that might be where Chillie has learned to believe that you can have confidential witnesses, but he can't. He can't. This is something that would break due process if each side had their own witnesses that were confidential and the other side couldn't cross-examine them, etc., or find out who they are to depose them, issue a subpoena for a deposition, do background checks and things like that. So it's silly and naive of him to think that he could have a confidential witness that's going to attest anything. The court can't determine the veracity of someone who the court doesn't know their name of, and the other side has to have an opportunity to know who these people are, who's testifying against them. And what's hilarious is that this John Doe is the same one that actually emailed the court and appeared at the hearing that Chillie declined to go to because this guy was scared of Chillie, not of Kate. So this is all just ironic and hilarious. Doe is in fear for their safety due to the past harassment of Masshole towards its victims, and especially Masshole members that betray the organization. Doe has a respectable job and fears doxing, his employer contacted, and his family members trolled, which is the modus operandi of Masshole. Doe sent me screenshots of Peter Abrams, non-party attorney John E. Rietveld II, Rietveld, California, SBN 320086. Congratulations on finally getting that right, you moron. And other individuals of Masshole using Wicker, a text messaging platform that deletes messages after they're read. The screenshots of the parties using Wicker appear to be from September 30, 2022. Now, if you have the screenshots, then why do you need them? Have you thought about that, Chillie? Have you thought about what you're claiming? When you sent me the screenshots that you said you were going to accuse them of spoliation, if you have screenshots, what did they need to save? Dummy. The screenshots of the parties using Wicker appear to be from September 30, 2022, which is after both defendant parties filed their ex parte extensions of time, the ex parte extensions having been filed without any cause stated. Yeah, there was cause stated. Just because you don't understand it doesn't mean it wasn't stated. This is even further after the parties were served summons in this action, and even further after the parties expected pending legal action. I also sent requests for production of documents to both parties dated October 6, 2022, reminding them of their obligation to preserve evidence. The requests for production were sent more than 21 days after service, as allowed under FRCP. The RFPs were mistakenly mailed to the court and should be on file with this court. As a pro se filer, the docket number is unknown. Yep. I don't think that you could just send out your discovery request 21 days after service without, I don't know. I think there might be one or two rules of civil procedure that you haven't complied with yet there, buddy. The nature of the Wicker messages was simply trolling activity, also known as trash talking of me and some of my products, tracking my location and sharing it with the Masshole officers, and discussing hiring people to launch a new harassment campaign against me. These messages would not be privileged and in the extreme would be dual purpose and must be preserved for evidence. You have screenshots of them. You're not being prejudiced by not having Kate preserve something that you already have screenshots of. Although my current complaint is only for defamation, the defendants are aware that trade libel is defamation. Trade libel. Oh boy. Whew, Dr. Law's been doing some research for you. The complaint will also be amended to include harassment. Conspiracy. Conspiracy to what? Conspiracy is not a tort. Conspiracy to do something might be a crime. You know, conspiracy to commit assault would be a crime, just like assault is a crime. But conspiracy in and of itself is a word. You know, I could conspire with my wife to take the dogs out. I could do that. That doesn't make it a crime. And other torts under both California and federal other unnamed torts. I plan on amending my complaint. I haven't done it yet because I'm being an asshole. But I'm planning on amending it. Yeah. Okay. My complaint will be amended to include California law. Defendants are aware of my intention to amend my complaint. I am still waiting on my motion to stay defendant's ex parte extensions of time, which was pled in the alternative on my opposition, which I mailed to the court on October 3rd, 2022, as a decision on that motion will make anything after moot. You're, the court already denied your opposition. The court already denied it. The court already denied it. I thought I went over this. Chillie, request for default. Chillie big mad. I thought I went over it. Let's see if I could log into Pacer without giving everybody my account information. I want to go to Mass District Court. Are you going to be able to do this? You can do this, buddy. You can do it. You can do it. All right. And let's see what we've got here. 22 CV 11421. See if I guessed right. Invalid number. Damn it. Did not. 22 CV 11421. I missed a 1. 11421. Wait. I didn't. 11421. 11421. Ah, I fat fingered it. My bad. There we go. It's these kind of things that really endear you to my videos. I want it was somewhere around. It was somewhere around. F it. We'll pay the money. I think we'll pay the money. Cancel. Run report. Do it. Pull it up. All right. All right. There we go. So the judge denied your applications for entry, and the reason why is because the court has granted the motions. Your opposition was ruled on prior to you filing your opposition because the court had already granted the motions. See, the court granted the motion, that's done. No longer on the table. Court granted the motion, it's done. No longer on the table. Then you file an opposition and another opposition. So the court had already granted the motions. So the ruling is already done. You lost before it was filed. Okay, where are we at? No, we're on this one. We're on this one. So yeah, you keep on waiting there, Chillie. I don't know what it's going to take for you to figure it out, but you lost on your opposition because the motion was already granted before you filed your opposition. I know you don't believe me. I'm just a first-year family law attorney, but trust me, once the court granted the motion, any further opposition was just a waste of time. Doe will testify that defendants and Rietveld used Wicker on September 30, 2022, and continued to use Wicker after that date. I am requesting leave of this court to file a sealed affidavit and documentary evidence. Wicker screenshots. You have the Wicker screenshots. You don't need anything else. Defendant Peter, instead of using the email address that I put on my complaint, investigated and found a personal email address that's public record because he used it in other cases. I am alaskan@gmail.com that I have never published. Except when you used it in your Ironton lawsuit, buddy. Peter then used that email address in her "I haven't looked for a lawyer" letter to the court, making my private email address public record. Except it was already public record. This is the type of game that Peter's been playing with my personal information since her harassment of me started. It is surely intentional and an abuse of the court system. Unless defendant Peter, with a small p, can show a court document or an email from me showing that email address, she will be unable to prove that it was not an intentional violation of my right to privacy and abuse of the process of this court for improper and harassing submissions. Now, if he has never published IamAlaskan@gmail.com, if he had never published it, how did Kate get it? Right? Think about that for a minute. Like, you're the judge, and like, okay, he never published his email address. Well, how did Kate get it then? How did Kate get it? How does Kate get an email address that has never been published? Well, obviously, there's the most obvious way. Like, if you're the judge and you don't know that he used it in his Ironton lawsuit, you'd say, oh, well, he must have emailed it to Kate. He must have emailed Kate using that email address. Right? So, like, he's stupid. Oh my God, a private email address. Yeah, I mean, just stupid. And apparently, according to Wish, the Ironton email address, he has listed his email in the court docket. Oh, really? Let's check that out. So let's do documents 1-1, and we just want parties and counsel. Run report. Oh, would you look at that? Well, gosh golly, says Jose Maria de Castro. How did she get IamAlaskan@gmail.com? How could she possibly have gotten that? Oh, she must be doing some kind of cyber stalking to get that email address. You dunce cap. You dunce cap. I can't do it properly. I love his dunce cap. It's awesome. Defendant's counsel, Benjamin Wish, told me on the phone on October 18, 2022, in part and in general, that he would love to litigate this case on the merits, but due to the fire hose of information he's being bombarded with, he does not yet know what the facts are. I would love to see that. Wish is preparing a frivolous defense. Oh, really? Has made no effort to confer. Oh, really? And has not looked at the evidence. All right. So, generally speaking, you should meet and confer before, like, you meet and confer to come up with a discovery plan, right? You meet and confer, generally speaking, before you file non-emergency motions to see if you can resolve it without having to waste the court's time and money. But I don't know what he's saying. Like, I've seen emails from Wish where Wish is like, hey, do you want to send me your amended complaint and I'll respond to that? No, says Chillie. No, you got to respond to the original complaint. Yeah. So, like, that's actually conferring, Chillie, when he's like, hey, how about we do this? How about we streamline the process? The point of conferring is to streamline the judicial process, to streamline the litigation and not waste time on frivolous little side things that the party should be able to meet and confer on and resolve without dragging the court in. Now, sometimes you can't come to a resolution without dragging the court in, and that sucks, but and just saying that you're preparing a frivolous defense, like, since Wish has not filed a responsive pleading to the complaint, he has not filed an answer to the complaint. How does Chillie know that Wish is preparing a frivolous defense? How are you going to convince the court, Chillie, that you know what Wish is preparing. Wish is an attorney. He's a professional. He's not going to tell you what he's preparing. He's going to prepare it and file it. He's not going to clue you in on his work product. There's a thing called work product, attorney work product. It's privileged. The other side doesn't get to know about it. How the attorney is thinking, what he's going to do, what his trial strategy is, what his litigation strategy is. That's work product. That's attorney work product. You don't know what he's doing. And even if he told you using small words what he's doing, you're too stupid and uneducated to understand. I'll be honest with you. Like, he could spell it out for you with those blocks that have all the letters on them that kids stack up. He could spell it out to you with those, and you still wouldn't get it. And he's not looked at the evidence. He doesn't have to look at the evidence yet. Evidence, like, he's going to give you his evidence, and you're going to give him yours after you guys come up with a discovery plan. After that, then you'll exchange evidence, and you'll both have the evidence. Like, he's not under a deadline right now to look at evidence. Silly. My declaration in the original complaint shows defamation per se by defendant Peter. And your point? You still have to go to court to prove it. You still have to go to trial to prove it. Now, if you guys agree on all the facts and it's defamation per se as a matter of law, maybe. But he doesn't have to not defend on it. It was made in a YouTube video that is still published. There was no later retraction. And remember, defamation can be defeated in a couple ways. One way is if you don't have a good character. Another way is if the statement is true. Truth is a defense to defamation. She gets an opportunity to show that what she said is true. The defamatory state is even in the text title of the video. Additionally, since Wish's very first document filed in this action, in his certifications of service, he insists on serving me by email when I never consented, and he knows that. He knows that I am a foreign? Is Chillie not a U.S. citizen? Huh. I thought he was a U.S. citizen. I never suspected he was a foreigner. Huh. He knows that I'm a foreign pro se. Is English his first language? I mean, that might explain some stuff. He knows that I'm a foreign pro se party and insists that I accept his email notices with no time to file responses, yet refuses to accept my notice to him that I cannot accept the notice by email, which shouldn't even be required, as the absence of consent should be sufficient. Wish is also aware of the spoliation of evidence, but is deciding to delay my filing for relief. Wish knew that I could not talk to him on behalf of defendant Peter until I was served with a notice of appearance. Dude, you're signed up for the system. I showed it in the other video that you have electronically filed. You are in the ECF or EMECF, whatever it is. I forget the name. I suppose I could look. CMECF. Like, dude, you're in there. You don't want to be, but you are. Tough titty, said the kitty when the milk went dry. And yes, you can't. So by the way, here's something funny that Chillie's never even paused to consider. Attorneys can represent clients before a lawsuit is even filed. And oftentimes, as an attorney, you're representing your client. You send a demand letter or something to the person who your client thinks has wronged them. They will get an attorney, and then the two attorneys will talk to each other without having filed anything, let alone a certificate of appearance. So an attorney can represent a party without, I mean, like, you should have just dealt with him, especially since you could check Pacer and you could see that he was the attorney of record. I mean, you knew enough, if I remember correctly, that you started sending out this guy's Benjamin Wish. It's a matter of public record that he's representing people I'm suing. And when did you send that out? Well, that's from his email. That's from his initial email. You sent that out from his initial email. So you knew that he was representing you, or he was representing Kate. You knew that then. And yet you still wouldn't talk to him. So you're being stupid. You're being stupid. And the fact that you filed this after this was filed even further cements how stupid you are. Like, it's one of the difficulties in dealing with someone this stupid is like, it's like a fractal pattern of stupidity. Like, every stupid thing leads to like 5 more stupid things. And each one of those 5 stupid things leads to like 5 more stupid things. It's a never ending pattern of stupidity. Oh, I'm getting goosefraba. Goosefraba. Wish knew this, but instead of couriering me the notice of appearance, he took his time. He emailed it to you, which is even faster than couriering. And I just got this notice on October 18, 2022. I immediately attempted to confer with him, including for this motion, even though it was past the deadline that I had asked defendant Peter to confer. Wish knew about this deadline, but showed no hurry, obviously just trying to delay my filing of my motion. Wish provided his phone number, but was completely unavailable until he finally answered the phone 4 minutes before an alleged emergency status conference that he had requested with me. Well, yeah, he was busy preparing his request for emergency status conference. He then simply said that the above that he hasn't had the time to look at the facts and didn't have time to confer due to the hearing. Well, yeah, a motion for spoliation before you've done discovery is pretty stupid because you don't know what she can or can't produce. You don't know what she's kept or destroyed. You dummy, you dunce cap. Of course the attorney's not going to give your stupid motion for spoliation any credence because you haven't done discovery yet. You don't know what's spoiled. And now you submitted that you have screenshots of everything. You've just completely undermined everything that you were asking for, you dunce cap. Oh. I told him that I simply could not attend a motion where he had filed evidence. He'd filed evidence. You file evidence now for a motion. Oh my God, you don't file evidence for a motion. You submit attachments and affidavits. Evidence is something that happens at a evidentiary hearing where you submit evidence to the court, or will you establish evidence, and then you can submit the evidence to the court as part of the trial record. The exhibits, these things, I guess technically it could be considered evidence, but this is an attachment. That's all it is. It's like, I don't understand what he thinks he's going to do. So normally to undermine evidence or to establish evidence, there has to be some testimony involved establishing. I guess technically a court could take judicial notice of certain kinds of evidence, and some kinds of evidence are what do they call that? Self-identifying or self-establishing, or they like a newspaper. It establishes itself. Like if you, I'd like to submit this article. Look at this article. This was in the newspaper. That it doesn't mean it's true, but it's anyway. I'm getting off on a tangent. Yeah, an ex parte hearing, an emergency hearing. Uh, he'd filed it on an affidavit. Uh, you not showing up doesn't really do much to help you. Um, yeah, filing evidence in response. And what does this have to do with spoliation? And what does this have to do? Like this is your motion, and the only motion you have in here, or the only part about, so you got the spoliation, and you've got the stupid shit about your email address, and that's it. That's it. Like this is so stupid. Like all of this is stupid. Like this has nothing to do with his with his motion for spoliation, and now apparently for abuse of process. Stupid. And he says he still hasn't received proper service. Congratulations. Good luck on that. Law and argument. All right, so we're gonna look at the law here, folks. You ready? You buckled in? I'm gonna take a sip of this sparkling water that's probably flat by now. Refreshing. These facts demonstrate that, at a minimum, I am entitled to an adverse inference instruction and award of attorney's fees and expenses. You don't have an attorney, you're not entitled to attorney's fees. You may be entitled to costs, but what did it cost you to file this motion? Was there a filing fee associated with filing this motion? That might be, at most, what you're entitled to. Might be. Now, sanctions are the more appropriate remedy. The court would favor sanctions. If the court finds spoliation, sanctions are a much more likely thing that the court will order before attorney's fees and costs. But you don't have an attorney, you're not entitled to attorney's fees. In sum, defendants and non-party attorneys were obligated to preserve evidence, was notified of their obligation by me in writing, yet inexplicably failed to comply with their obligations, and willfully and intentionally destroyed the spoliated text messages. You don't know that. You haven't conducted discovery. You don't know what has or has not been preserved. And you're not actually addressing all of the, would you look at this? Spoliation is the destruction or alteration of evidence or a failure to preserve evidence for use of the opposing party for pending or future litigation. Here, defendants willingly and knowingly destroyed highly relevant text message evidence. You have to establish that they're highly relevant. Since text messages are considered electronically stored information, Rule 37E of the Federal Rules of Civil Procedure guides the court's spoliation analysis, noting that Rule 37E applies to text messages because they're ESI. Rule 37E contains two general levels of sanctions, the imposition of which depends on the spoliating party's level of culpability. If the court finds the defendant did not act with the intent to deprive the litigant of the information during litigation, but the spoliation prejudices plaintiff, the court may only order measures no greater than necessary to cure the prejudice. If, however, the court finds the defendant acted with the intent to deprive plaintiff of information for use in the litigation, much harsher penalties, including adverse inferences, are available. So the court needs to define that the spoliation prejudices the defendant. Number one, that there is spoliation, and number two, that it prejudices the plaintiff. Spoliation, it has to prejudice the non-moving party. No, it has to prejudice the moving party. That's what it does. Now, Chillie has to prove that. He has to prove that, number one, spoliation happened, i.e., the defendants didn't preserve the information. Now, he's stupid, so he thinks that they would have to, contact, what's the name of that thing? Hold on a second. Whisker? Something like that. What's the name of it? Jesus Christ. Wicker. So he has to prove that So he thinks that they had to stop Wicker from destroying the texts. That's not the case. If if there was a duty to preserve these, which he hasn't established yet, then they can preserve it by taking screenshots of it. They can preserve it by emailing it in like a different form to themselves or whatever. As long as they preserve the information, that's the important part. They don't have to keep it in its original form. I mean, that's pretty common that a lot of times companies will like take their written records and will reduce them to electronic, like banks. They don't keep the actual original checks. They take images of the checks, and that's fine. And then let's say the bank, you find out that some issues coming up, and you contact your bank and you say, hey, you have images of these checks. I know the other party's going to need them in this lawsuit that they're filing. So why don't you go ahead and send them to me? And the bank sends them to you, and you print them out, and you hand printed on paper copies of those checks to the other party, and delete the electronic copy off your computer or whatever, your phone. Can the other party say, oh, spoliation? No, because you've given them the document. Just because it changed from an electronic copy to a paper copy doesn't change what it is. Now, there are some things that it wouldn't work for, but a text message is literally writing. Changing it to a screenshot doesn't destroy it. Rule 37E and its application. Rule 37E2's adverse inference analysis consists of two parts. First, plaintiff must establish defendant's spoliated evidence. That element is met because there's no doubt defendants spoliated evidence when they, 1, allowed relevant text messages to be destroyed, and those text messages cannot be restored or replaced through additional discovery, and 2, they should have preserved the text messages allegedly according to you they did, and number 3, failed to take reasonable steps to preserve the text messages. How do you know they didn't? You haven't done discovery yet. How do you know they didn't? How do you know they didn't? You're just asserting that they've destroyed, they've allowed them to be destroyed without preserving them in some form. You're just asserting it. This is so stupid. Like this is one of those fractal patterns of stupid. Second, in order for the rule's elevated sanctions to apply, plaintiff must establish defendant's spoliated evidence with the intent to deprive me of getting information in pending or future litigation. Okay. With intent. You got to show intent. This element is also met because it is obvious defendant spoliated these text messages with the intent. Oh, well, it's met because it's obvious. Just duh, court. Just duh. It's obvious. Duh. You have no idea how to prove anything, Chillie. You're stupid. Criminy. Defendants allowed the text messages to be destroyed, which cannot be recovered or restored, but you have screenshots of them. This is stupid. By affidavit of Doe, which is completely not going to be even thought of by the court other than as bad against you, because Doe contacted the court, you numbskull, and said you were blackmailing him with evidence that will impeach any testimony. With evidence that will impeach any testimony. Whoa. Defense inability to produce the messages in the screenshots in their opposition to this motion. They don't have to produce them in opposition to the motion, you dunce cap. They don't have to produce them. You bear the burden of proof. You have to prove they were destroyed. Now, how normally it's done, how what we like to call lawyers do it, is lawyers, after you have a discovery plan in place, will submit a request for discovery, request for production of X. If they don't produce X, you say why. I'm going to file a motion to compel if you don't produce it. And they say, well, it was a Wicker app, and Wicker deleted it, and we didn't save copies of anything. Oh, so you're saying it's destroyed? Yeah, it was destroyed. Oh, well, then I could take that to the court, and I could have that as an affidavit. On this date at this time, I talked to opposing counsel, and he advised me that the requested documents had been destroyed, that they had not been preserved for litigation. And that's how you bear your burden of proof. Because they said that it was destroyed. You're saying it's destroyed, Chillie, you dunce cap. And they haven't said anything. They don't have to say anything because you bear the burden of proof. They don't have to prove you wrong. You have to prove yourself right. And you're just assuming that the court's going to believe that these things were destroyed when they've had no obligation to produce them. You dunce cap. Defendants intended to deprive plaintiff of the spoliated text messages in this litigation. Here, defendants' destruction of text messages, which you assume were destroyed, after being sued, and their complete failure to institute any steps to preserve relevant evidence for months proves their intent to deprive me of the use of that evidence in this litigation. And yet you have screenshots of them. Intent rarely is proved by direct evidence, and a district court has substantial leeway to determine intent through consideration of circumstantial evidence, witness credibility, which you don't have with the Doe witness, especially when your Doe witness turns out to actually have a name, has given the court his name, and has said that you're blackmailing him. Motives of the witnesses in a particular case, and other factors. So your blackmailed witness had motivations. Oh, and I did catch like 2 minutes of his stream where he was pulling over on the side of the road, and he starts talking about, the witness. I wasn't going to name him. I was going to protect his identity. But now I guess he doesn't need his name protected anymore. So now you're going to dox the guy. I mean, like, it's just so blatant and stupid, and I almost can't believe that it's happening. This is so cartoonish. It's cartoonish and stupid. And I want to believe that it's just some huge troll cooked up by Kate and Chillie to get their subscriber count up, to generate income. But at the same time, I think it's real. And that bothers me that there's people this stupid out there pretending to be constitutional law professors. I mean, this is just terrible. There need not be a smoking gun to prove intent, but there must be evidence of a serious and specific sort of culpability regarding the loss of relevant ESI. Prove that there's a loss, you dunce cap. Here there is serious and specific evidence demonstrating defendant's culpability in his text message spoliation. So lay out that serious and specific evidence. What evidence do you have? Defendant's spoliation timeline and knowledge of using a platform that has a unique feature of deleting messages after they're read belie any arguments that defendants inadvertently or negligently allowed destruction of their spoliated text messages. Here's the problem, Chillie. You have to prove that what they said to the court, you have to show what these text messages contain was relevant to this litigation in some way. And that not having that is harmful to your case. Those are two things you need. You also need to prove that it was destroyed, that these things actually were deleted or lost, and the defendants can't produce them. You haven't been able to show any of that. All you've done is admit that you have screen captures of it or screenshots of it. That's all you've done. You dunce cap. Awarding and blah, blah, blah. Defendants are obligated to preserve these messages, and their complete disregard of that obligation evinces their intent to deprive me of their use. No, that's not how it works. Cruz G-Star Incorporated is an instructive case in which the United States District Court for the Southern District of New York found intent to deprive and granted an adverse inference. Like the defendants in Cruz, defendant spoliated evidence after consulting with his counsel and after failing to take any reasonable steps to preserve his text messages prior to their deletion. Okay, let's just look this up, because why not? Cruz versus G-Star. Is it G-Star? All right. Denim clothing. Plaintiff is an Asian woman. Employed by the defendants. Plaintiff alleges that she was not paid overtime. She made complaints to Human Resources. deletion of plaintiff's email account and notice of claim. On January 27, 2017, they shut down her email account. According to the manager, when an employee is terminated, human resources informs the IT help desk of the termination. As per the date of termination, the Windows account, which includes emails, immediately shut down. That means the account is locked. The user cannot access or use it. After 2 months after an individual's employment ends, the Windows account is deleted unless an instruction has been received to hold the account for litigation purposes or some other purpose. The ICT department saw that plaintiff's Windows account not yet been deleted. There's no record of a hold having been placed, so they proceed with the deletion. The plaintiff's counsel stated he called the defendants in or around late March of 2017. So, late March, and left a message that they were contemplating bringing action against defendants. So plaintiff provide defendants in-house counsel with an extended list of documents that were needed. Copy of that email is not in the record, but Kandar represents, she told the clients that we eventually have to produce many of the emails from the years of Hazel's employment. I'll work on a list of reasonable search terms. She didn't know the plaintiff's emails have been deleted, assumed they had been preserved based on her specific message of plaintiff's emails on the list she provided on October 2 of 2017. So on March 8th, she served her first request for production of documents. See, that's normally how you figure out spoliation. Demanded documents, communications sufficient to evidence date and time of plaintiff's logins or use. Defendant's in-house counsel directed blah blah to search for various emails and not to delete the account for Hazel Cruz. And that's when they found out it had already been deleted. As a result, plaintiff's SAP account was locked on May 17, 2017, and finally deleted end of December 2017. Okay. Anyway, I don't know how this at all relates. They weren't using a messaging app that automatically deleted things, so I'm not sure that that's entirely appropriate. I don't think it's a real good fit. The Cruz Court granted adverse inference, noting it would serve the prophylactic and punitive rationales for such instruction, deterring such instruction, and properly placing the risk of erroneous judgment on a party that wrongfully created the risk. Yeah, there's a bit of a difference though with deleting the work email account of someone who would have had documents that were showing various things after litigation was filed, but those are documents the plaintiff had and could point at and needed those documents to help her claim, as opposed to documents the plaintiff is not aware of, that he doesn't know the contents of, that his claims aren't based on, in a messaging app that deletes, like a Snapchat or something. There is a difference. I think it is distinguishable. But he's really banking on this Cruz Court thing. I don't think the Cruz Court is a really good fit. The Cruz Court also knows an adverse inference instruction serves a remedial function of restoring the prejudiced party to the same position she would have been in absent the wrongful destruction of evidence by the opposing party. as defendant's destruction limited the universe of documents available for plaintiff use in this litigation. Like Cruz, the court should sanction defendant's willful efforts to deprive me of ESI necessary. In Cruz, it wasn't willful. The Cruz court didn't find it was willful. So there's a problem. So he wants an adverse inference instruction against defendants. In addition, he respectfully requests reasonable attorney's fees pursuant to Rule 37. FRCP Rule 37. No, I know. I remember 37. They can, you can ask for attorney's fees. Wait, no, those are the. That's right. 37E. So this one is, you got those. Presume you only got 3 options. I don't think you can get attorney's fees out of it. And you still don't have an attorney, so that's not happening. Oh, some do, huh? So you have a Middle District of Florida and what the hell's this? An unpublished one? Wow, 2 unpublished decisions that they're relying on. Good luck. Defendants Peter and Abrams have refused. Someone has a Lexus account and doesn't really know how to use it. Defendant Peter and Abrams have refused to confer regarding this motion. I wish I had a Lexus account or a Westlaw. That'd be awesome. They're expensive as hell, though. Have refused to confer regarding this motion. Said they delayed conferring with me until 4 minutes before an alleged emergency status conference that I did not receive proper notice of. I'm at a great disadvantage if the defendants file evidence with a motion. Why are you talking about this? You're supposed to be talking about your spoliation, dude. And I'm unable to file evidence in response before attending a telephonic conference where only testimony can be heard. Testimony is evidence, you dunce cap. I'm not required to waive my right of proper service, and a duty to waive that right would be greatly prejudicial against me. You already have, dude. It's done. It is clear by these tactics the defendants are likely to oppose this motion, but they are also using unfair strategies to try to prevent my filing of it. No one tried to prevent your filing of it, you dunce cap. This is evidence toward their culpability and against their credibility. No, it's not, you dunce cap. Sanctions against non-party attorneys. While non-party attorneys do fall under rules for sanctions, there are 2 questions. One question in this case might be whether non-party Rietveld is actually a party or actually a party's attorney and is eligible for interlocutory appeal to a sanction ruling. The other question is whether sanctions should be continued until after the 26F conference because the court may not have jurisdiction over non-party until service of a subpoena. So, yeah, I mean, that might be something, but the question of whether I'm actually a party, that is a weird question that you'd ask. You wrote the complaint. You didn't name me as a party, you dunce cap. And I'm obviously not a party's attorney, at least as far as this particular proceeding is going, you dunce cap. And if I'm not representing a party in this particular proceeding, I am not a non-party attorney for this proceeding. See, he's thinking when it says non-party attorney that somehow that means that the court can have jurisdiction over a non-party person who also happens to be an attorney. But he's a dunce cap. A non-party attorney is an attorney representing a party, but the attorney isn't himself a party. Dunce cap. Sanctions for abuse of process. Under FRCP 11B, a party represents the submissions are not being made in being presented for improper purpose, such as to harass, yada yada. She should receive sanctions for including my email address in her submission to the court. No, she shouldn't, because you listed it, you dunce cap. and Wish should be receive sanctions for making a frivolous defense. Your allegation was that he was planning on making a frivolous defense. You idiot! And now he should be sanctioned for something that he hasn't done. Oh God, it just hurts my brain. Under these circumstances, an adverse inference and jury instruction. And what sanctions would I be liable for, you idiot? Under these circumstances, an adverse inference and jury instruction sanction against defendants is appropriate because they willfully allowed relevant, responsive, you haven't shown they're relevant, you haven't shown they're responsive text messages to be deleted, you haven't shown they've been deleted on multiple occasions, despite previously receiving a hold that explicitly directed them to preserve their text messages. Okay? You haven't even shown it's the parties. You've alleged, but you haven't shown anything. Defendants acted intentionally, and your only witness turned against you. I just keep wanting to remind people of that. You blackmailed a witness who told the court he was being blackmailed by you. Dunce cap. Defendants acted intentionally to deprive me of the use of this evidence in litigation. Sanctions pursuant to Rule 37E2 are appropriate. 37E2. That's that stuff. Are appropriate for all the reasons set forth above. I respectfully request the court grant my motion, provide adverse inference instruction to the jury at any trial of this matter, and award me the reasonable costs and expenses I incurred in securing this relief. So, yeah, costs and expenses, sure. Attorney's fees, no. So anyway, that's it. So long story short is we've got the emergency motion to dismiss coming up on Monday. Chillie has not, as far as I am aware, prepared and filed a opposition to that motion. It will be interesting to see what Dr. Law can poop out over the weekend. But yeah, Dr. Law should really get cranking on it. My best guess, if I was ranking these various outcomes in order of probability, I would say the most probable outcome is some sort of an order from the court saying that Chillie can only interact with the attorneys and not with the represented parties, and that he has to remain civil. I think that's, as far as Kate's motion, that I think that's by far the most likely outcome. The second most likely outcome is the dismissal with prejudice. The third most likely outcome is the I think the third most likely outcome would probably be denial of Kate's motion. Fourth most likely outcome would be the permanent injunctive relief. I would be surprised if a court granted that. I would be shocked. I'm not saying that a court couldn't. I would just be shocked. I would be shocked. So on Kate's motion, that's my probable outcome range. Again, I'm not saying that the court would not do any of these things. I'm just saying that probability-wise, as far as a first-year family law attorney's perspective on what he thinks is going to come out based on the filings he's seen so far, is it's probably going to be some sort of an order just saying everybody be cool. As far as Chillie's motion for spoliation, that is going to fall flat. It's not going anywhere. It doesn't have any traction. Nothing in his pleadings about the abuse of process or spoliation make any sense or are supported by any good facts or testimony. So that's just huge odds of the court just flatly denying it. Minuscule odds of the court granting an adverse inference, and minuscule, like super tiny. An infinitesimally small chance of being awarded any costs. I don't think that he had to pay any filing fee to file a motion, but if he did, I think he would get that back. I haven't filed a motion in a federal court case in forever and a day. So I don't remember if there is a filing fee associated with it. I know state court there is, but I don't remember in federal court. If there is one, he might infinitesimally small, like 1 in a million, maybe. The odds of him getting sanctions against me or sanctions against Wish are zero. Just not going to happen. Not a snowball's chance in hell. Good luck. Good fucking luck. Like you're so far out in left field, dude. You're not even on the planet anymore. Eh. All right. Anyway, so that's it for today. Sorry it's such a long video. We had a lot to go over. Thanks for watching. Have a great day.